Hello again, everybody. Very nice to see you all. Just by way of background about me as a lawyer, I qualified as a barrister in England in 1996, and I've been qualified in Jersey since 2008. My specialism is actually employment law. I was talking to Charles at the last Tech Tribes event. He said I'd be delighted to do a talk if anybody would like one. And when he said yes, I was thinking about what might be interesting or relevant to people here. And data protection and defamation are both very, very topical. So when you start off thinking, well, what sort of law might be relevant to technology, the answer is, well, exactly the same kinds of law as are relevant to every other kind of business, and then some additional ones as well. So it's pretty much all kinds of law are relevant to technology businesses. Data protection and defamation, though, I think are two particularly topical issues. And one area that links them is blogging and posting, so I'm going to look at that. What is data protection? Well, it's protection of the rights of an individual in relation to information about him or her. It's about preventing the misuse of people's personal data. And originally, when data protection law was being set up, it was to do with data or information that's being processed automatically on computers and through technology. Now, of course, that is the vast majority of data. So actually, data protection now concerns almost all information about us. The word about us, or the concept of it being information that is about somebody, is quite important. So personal data is data, and interestingly, as my mum pointed out, it's a plural in the law, but it's data that relate to a living individual who can be identified from those data or from those data and other information in the possession of the data controller, and it includes an expression of opinion. Now, recently on the Digital Jersey LinkedIn page, there was a thread about data protection and managing corporate data. And somebody was saying, don't forget that every mention of a name will constitute personal data and will have to be disclosed if there's a data subject access request. I don't think that's necessarily true. A name alone may not constitute personal data. So it's going to be the name and a bit more. So for example, if you've got email chains and you've got me copied in, so it's CC Vicky Milner on all of these different emails, that doesn't mean that just having my name there is personal data which will be disclosable in response to a data subject access request. Just having my name there isn't information about me as a person. Now, in addition to data controllers and data processors thinking about their responsibilities in relation to dealing with personal data, of course, you've then got those responsibilities plus when you're dealing with sensitive personal data. And sensitive personal data, it's limited. It is only the things which are on here which constitute sensitive personal data. It's quite an interesting range. Somebody said to me, well, why would you have trade union membership on here? And I think that's quite an interesting question. I think that's probably historical. It will date back to times when people could be blacklisted or could be prejudiced if people found out that, that they were a trade union member. And so I think it probably goes back to that. But so you've got quite a broad list there. And one of the most common things, obviously, that will come up when you're thinking about use of personal data and sensitive personal data will be any information to do with somebody's health, their physical or mental health or condition. So I wanted to just touch on an example. Thinking about website sales and what sort of personal data issues might we have to think about. So we have an example of Anthea. Now, she's a lovely herbalist who lives somewhere in Scotland, and she makes this fantastic foot cream. She makes lots of other things as well, but she makes a really fantastic foot cream. And what she does, she's a bit like me probably. She's very non-techie, doesn't know anything about websites, but her foot cream is good. And what she does is normally when she meets people to sell this stuff to them, she asks her clients about themselves. So she gets them to fill in a really mini questionnaire. And so they have to give her their name, their age, and tell Anthea about their feet and about the problems with their feet that mean they need the foot cream. So they're providing some medical information to her, some information about their health when they're sending information about the state of their feet. So anyway, Anthea, somebody's told Anthea, great product, but you know, you could really do much better than you are doing if you start selling this online. So she said, crikey, you know, don't know anything about that stuff. But She gets introduced to Barry, who's a website designer and an online salesman. Now, I don't know if these jobs go together, but for our purposes today, they do. So Barry's going to do all of the tech stuff, including managing the sales. So what we would obviously originally have is Anthea would be dealing with her clients face-to-face. So they would be telling her stuff, they would be providing her with her personal data, and then they'd be giving her some money, she'd give them the cream. Now, of course, we have a third party brought into the chain. So we've got Barry there, who's dealing with all of the online stuff and all the sales. And what they've decided is that each time somebody clicks onto the website and says, I'm interested in your foot cream, they will automatically get sent out a mini survey, which will say, please fill in your name, your date of birth, and tell us about what your foot condition is, so that we know whether or not this is an appropriate product for you. And of course, what that means is that instead of it just being Anthea who has the person's sensitive personal data, the information about their feet, obviously Barry has got that information as well. So clients give that information to Barry, Barry's giving it to Anthea, so you've got these chains. Something I've been looking at quite recently is the distinction between data controllers and data processors. And this is relevant when you're running a business and when you're working with other people, when you're working with subcontractors, for example, or suppliers. So you need to think about who has ultimate responsibility for what happens to personal data. So here, if it's Anthea who is the owner of the business, and she's requesting the personal data in the first place, and she's asking Barry simply to manage that for her and to manage it on her behalf, then Anthea will be the data controller and Barry is the data processor. And this becomes particularly relevant when one's thinking about data subject to access requests. Those obviously have to be made to the right people. The responsibilities are different. When you come to think about that, the key things here from a business perspective are going to be, it's all about your terms and conditions. Do your terms and conditions work contractually? Are they clear? Are they straightforward? So Anthea would need to think both about her contract with Barry, and she would also need to think about the actual contract with the client. So you've got two different, you've got your business-to-business contracts and you've got your business-client contract as well, and the terms and conditions that are going to go in there to cover your data protection use. So we've got this sort of network of links. So that's all fine. Everybody's comfy with that. They fill in their little wee questionnaire and it says, we can use your data and we'll sell you some foot cream, and that's all super. All good. Now, we could have another chap called Cedric, who Barry could meet in the pub. And Barry says, I've just started working with her in Scotland, she has really good foot cream, I'm doing all the sales for her. And Cedric says, that's so funny because I sell fantastic orthopedic shoes. It would be perfect if I had access to her clients because of course there would be absolutely target audience for my product. So Barry and Cedric then have this conversation and start thinking about whether, for example, Barry can sell Cedric some of this information or just refer people to him, or what they might do to work together. And I'm sure this is also very positive, that they're well intentioned about this. They want to help people's feet. Maybe make a bit of cash on the side, but So then we're thinking about another relationship, and the reason the arrow is in a different colour is because we've got to think about, would that be a legitimate use of the personal data? And the answer might be, if the clients have consented to it, absolutely. So if when you sent out your questionnaire you said, and we also have access to someone who sells terrific shoes that we find are really good for problem feet, might all be fine. But obviously you've got to have that consent at the outset, because otherwise you're going to be committing data protection offences, potentially. And/or the same would apply, obviously, if Anthea was doing this. So if she decided to set up an arrangement directly with Cedric, then whether or not Barry's involved, there are also going to be issues about what they're doing with that personal data. So these are some of the points that I've touched on. Think about, when you're looking at your contractual terms, who's the data controller, who's the data processor, what do each of them need to do? I think with data subject access requests, they're one of those things that nobody worries about until they happen. And they can be a colossal pain. And then you have to start unravelling everything, and you find out you haven't filed your records properly and you can't get them, and it's all mixed in with other people's data, and a total shocker. So it's a really good thing to think about at the beginning and try doing some dummy run data subject access requests. One of the things that I would say, we'll touch on clear contractual terms, do take some advice on this issue. The Data Protection Commissioner's Office is there to help. It's there to help members of the public, to help consumers, but it's also there to help businesses. So you don't necessarily need to pay for advice. You could go and speak to them. They have a website as well. But get comfortable with this stuff, think about it. It is always easier to deal with problems should they arise if you've had a look at it beforehand. Now, normally data protection you think of as sort of fairly, potentially a bit dull, a bit anodyne, but we have had one prosecution in Jersey, and blogging about people, I mean it sounds really, really obvious, but blogging about people may raise data protection issues. So the classic thing would be, if we had, you remember Cedric, the guy with the foot, with the shoes, that's what you call them. If he started blogging, or Barry started blogging about the terrible photos he'd seen about manky feet, and he identified the people in question, then he'd be using their sensitive personal data in a way that breached the law. So far, so light-hearted. Well, we had, there was a case a few years ago in Jersey where a well-known public person he had control of a report that contained lots of people's sensitive personal data about a number of people. And he talked about this a lot on his blog, and then he ended up publishing this report on his blog. He was told to stop, he didn't, and he was prosecuted. He was successfully prosecuted. So by publishing that data and sensitive personal data on his website, he was committing a criminal offence, which he was prosecuted for. One of the interesting things about that particular case, and I'm going to come on to defamation, is that aside from the whole data protection offences, he was also extremely abusive about a number of people, and it was noted in the court's judgment about the data protection offences that many of the statements were defamatory. Now, when one's thinking about the difference between data protection offences and defamation, defamation will be a civil action. So if you defame me, I can sue you. A data protection prosecution would be brought by the Attorney General's office. So different people would bring these, would take proceedings. Defamation isn't very common because it's a civil claim. I would have to pay my costs of bringing that case and potentially the cost of the other side. So you don't see defamation cases very much, and slightly different tack, but I'll come back to that. Blogging also, and again, it's pretty obvious, but it does raise cyberbullying and harassment issues. Now, certainly I've read about in the UK lots of problems with this, trolling and this sort of thing, and it's perhaps a particular concern when it involves children, but pretty upsetting potentially for anybody. Again, in Jersey, we have had one case involving this. Some years ago in Jersey, there was a school, and a parent was very angry about something that had happened at a school, and he thought the school had got it wrong. So he set up his own website, and he started publishing very, very offensive statements about teachers at that school. And so they got an injunction against him. They went to court, and they got an injunction to prevent him doing that. And if he had breached that injunction, he would have been in contempt of court and could have been sent to prison. So action can be taken. These sorts of cases aren't common, but they can be brought, and they are brought from time to time. And these are prosecutions or injunctions. Those are going to be the most serious cases. It's not common, but it does happen from time to time. So, defamation. Well, what is defamation? Let's just remind ourselves. It's when you publish about a statement about somebody which lowers him or her in the minds of right-thinking members of society. Now, we didn't really have much law on defamation at all in Jersey, and we've got no written law about it. There's no statute. It's not like the UK where they have a Defamation Act. We don't have one of those. But the principle or the concept of defamation does apply here, and just earlier this year, we had the first defamation case brought in Jersey in about 100 years. So yes, defamation law alive and kicking in Jersey. And it is very relevant again when you think about online communications and blogging. So, as I said, pretty topical stuff, but interestingly, the key case here, I think, the really, really key case when it comes to internet service providers is this Godfrey and Demon Internet one, which goes back to 1999. I was amazed when I saw how old that case was. That case concerned a chap who was a lecturer called Mr. Godfrey, and Demon Internet was an ISP, and it published things that people posted on it. And somebody put a post on this website pretending to be from Godfrey. So it was a forgery, and apparently it was squalid, and it was obscene, and it was defamatory. So Godfrey got wind of this, and he contacted Demon and said, look, this was not by me, this is really offensive, this must come down immediately. And Demon did nothing, and they left it up there for several weeks. So he sued them for defamation. This is a UK case rather than a Jersey one. But he successfully sued them for defamation. They said, well, we didn't create this statement. You know, we are an innocent party. Somebody else put this up on our website. We did nothing. The court said, no, actually, you are responsible for this, particularly because you could have taken this down and you didn't. So the internet service provider was found liable for defamation for publishing that. And obviously what that reminds us of is that if you're going to post anything or you're going to have a website, let's say like this is Jersey where people can post anything they like about the news, you have to think about how you're going to monitor that and control it, and what you're going to do if there's something posted up there which is inoffensive or defamatory or inappropriate. So of course now what we tend to have on websites where other people can post is the report abuse tab. So that if somebody sees something and somebody's trolling about somebody else, they can click on that report abuse tab. Now, just having that tab, I don't think is going to be enough. You're not going to be expected to know everything all the time, immediately, but you're going to need to have some systems in place to monitor what other people are using your services for. And then the last case up there is the McAlpine and Sally Burko case, which is, really, really recent. And this is the first ever, well, I think, certainly in the UK, the first ever Twitter case. What's amazing about this case is how short her statement was. So the background to this is that so there were some very sad revelations about abuse in a children's home, and a man who'd been the victim of abuse went public and said, this happened to me, and the man who did this to me was a senior political figure in the Tory government. And somebody put one and one together and made three, and people on Twitter started mentioning Lord McAlpine. And then Sally Burko had a very well-connected Twitter account. I suspect she uses it less now, but she had many tens of thousands of followers. And she put up this very short sort of one-liner saying, why is Lord McAlpine trending on Twitter, innocent face? And that was found, but because of the context, it was all to do with the context, because this was in the Twitter atmosphere, where other people had already been starting to connect these, the court found that the way she did it was defamatory. She knew perfectly well what she was implying. She was implying Lord McAlpine was a paedophile. And what the judge was saying was that other people who read Twitter, not necessarily the whole world, but other people who read Twitter and could access Twitter, that's the conclusion that they would have drawn. And so she was found liable for defamation. So what conclusions do I draw from all this? Well, get comfortable with data protection law and think about how it applies to your business, think about your terms and conditions. If you have a website that other people can post on, think about how you're going to manage this. And of course, it's a statement of the complete flaming obvious, but think before you tweet or post or whatever else it is that you do. Any questions?
I run a small charity mailing for U3A. Half the addresses are on email, half of them are postal. The email addresses you just suggested that an email address is not something which is subject to data protection, so I can bulk email them.
Well, no, not necessarily, because you will have other information about them as well. I suspect is that if you have somebody's information that you hold in its entirety will be personal data. Are the individual email addresses personal data? Debatable. I don't know.
But if you were defending me, you could make a good case.
I'd say it hasn't come up in Jersey, and actually that email address doesn't say anything about me as an individual. So partly might depend on what the content of your email was.
It's just sending out notices of meetings.
Yeah. So is your question about doing a group email and if other people could see the email addresses?
Yes.
Now, I'm not a techie person, but I think, can't you set up a group account so that
you
you just
can,
say...
I prefer not to in this particular case, because it's basically an old people's group. You can see my white hair, and I like them to know each other's email addresses.
I wouldn't do it unless you've got their consent. I think it's better to, I mean, maybe it's a bit overcautious, but I understand that it's dead easy to get the group email address. And on that basis, you could, next time you email them, so I would do it as a group one without the individual's names, and say, is it okay if we share your data with other people in this group? So let's say Sally Burko defamed McAlpine, and McAlpine was living in Jersey.
Yeah.
So she was in England, and she did this through an English law governance system, but it could be read globally, and he was in Jersey.
Yeah.
He would still have the ability to, as far as I'm aware, the defamation law doesn't say, and this only applies to people living in England. So potentially it could have some laws have extraterritorial scope, some don't.
I was going to sort of say that if perhaps what was considered to be defamation in the UK wasn't considered to be defamation here.
Here, yeah. So what you probably then have is a bit of a battle about the law of which jurisdiction should apply. So
obviously the post or quote may have been made from Jersey, but the UK is finding it to be defamation, whereas Jersey law says it isn't.
Yeah.
So would it have to be prosecuted in the UK and you extradited as such?
So, well, yeah, you're going to have this conflict of laws jurisdiction issue, and you're going to have that battle as to, whether or not the person can just say, ha, I'm in this jurisdiction, you're over there, there's nothing you can do about it, or whether you get into it. So, actually, it applies to, a number of areas of law. But yeah, so you're likely to have that argument and that battle. Somebody might try and seek judgment in one country, and then they'd have to try and enforce it in the other. But so the fact that people are in other jurisdictions doesn't mean they have no can't still exercise rights under the law. It just gets a lot more complicated, and sometimes, as I say, some laws do have extraterritorial scope and some don't. So it will all, I'm afraid, it will all depend. I mean, if we look at the employment law, for example, the employment law of Jersey does not have extraterritorial scope. It only applies to people who are actually working in the islands. So it depends. And as we have no written, here in Jersey, we have no written defamation law. So it's difficult for me to say how it would apply to somebody elsewhere. I mean, I would have thought, you'd look at, it goes to this whole area called conflict of laws, where you say, well, okay, who was the bad person, who was the victim, where was the action? So it will have to be looked at on a case-by-case basis, I think, probably.
Okay, I'm sure Vicky will hang around and take questions after.